Hello, Fred Kuhn interviews our next guest expert. And now, here's Fred.
Our guests today are Lisa Barrington and Susan Savitt, both highly experienced HR and legal experts on sexual harassment, discrimination. The question I have right now, and this is really an important one. If I were an employer, what do I do to proactively avoid any of these claims of sexual harassment? What does an employer really need to do?
Thank you for that question, Fred. I think there's many things that an employer needs to do that can reduce the likelihood of claims. Keep in mind, anybody can make a claim at any time. It doesn't even have to be valid. That's their right. The issue is, how can you really defend your claim? And what do you need to do so you'll have a good defense in place? So the actions I'm going to share with you will help you set up this affirmative defense if you're charged. And first and foremost, as Susan has mentioned in a previous podcast, the foundation is having policies in place that are both clear and enforceable. So you should not only have policies that are visible, accessible, everyone knows where they are, they're very clear, but you need to keep them up to date because things change. Your organization changes. The law changes. The policy should include things like, what is sexual harassment? What do you do if you've witnessed it or experienced it? And what will happen to people who engage in that kind of behavior? So that's our policy piece. The next piece, very important, and frankly, some municipalities require this, is training. And I suggest that you should have two types of training, one for all of your employees and one for people who lead other people or manage other people. The U.S. Equal Employment Opportunity Commission, the EEOC, they've issued guidelines around this, and it does apply to employers in all states. And it states that they recommend and request that employers periodically provide harassment prevention training to all employees to ensure that they understand their rights and responsibilities. And as I've mentioned in another podcast, in California, Connecticut, and Maine, they require that employers provide sexual harassment prevention training. And also in other states, such as Colorado, Florida, Massachusetts, and several others, they encourage employers to provide training. I'm going to pause and see if Susan would like to comment on either of those two, and then I'll share with you three more things you need to do to ensure that you're putting yourself in a good position with an affirmative defense.
I don't have much to add other than you really have to have a policy regardless of what size an employer you are. And if you have more than one office, they may be looked at as an overall situation. So you have to have a policy. And if you have that policy, you have to be sure everybody has seen it or has received it. Some people have people sign that they received it. Some people have to sign that they received the personnel policy manual. Whatever you might have, if you're not a big employer and you can't afford to have a fancy manual, you still can distribute, and that's considered publication of the policies individually or on the internet. But you've got to be sure everybody receives it and knows about it. And if there are people they're supposed to speak to, you have to make them accessible. You might need a hotline number, all that kind of thing. And if you have a policy, you have to be sure you follow it. But from a defense point of view, I need you to have the policy, and I need you to have distributed it, and I need you to enforce it.
Okay, so we have a policy. Let's say we're a small company, maybe 15 or 20. And most small companies generally are kind of like families if you're that small. Everybody knows everybody else. And so doesn't it make it very difficult to report one to the other or report on someone? How do you set something in place so that there isn't that blowback?
That's a great question, Fred. So we're going to come to that in a little bit, but I'll give you the short answer. If you're a small organization or even a medium-sized organization that either doesn't have a human resources department or has a department, say, of one, and they're part of this kind of family environment, the best thing you can do in your policy is have an outside organization, whether it's a consultancy or a law firm, or just a neutral third party that can do investigations, that they're the point of contact for such complaints, and they will do a neutral third party investigation on behalf of the organization.
Got it.
May I ask you this question, Lisa? From an attorney's point of view, I have been asked advice from a HR person who worked for a small company, such as Fred alluded to, who claimed that the boss was harassing her. how would that person deal with the situation, and how should the employer
Excellent.
deal with that?
Thank you, Susan. Good question.
Excellent point. So certainly in a perfect world, we recommend that people sit down and talk to the person who's harassing them and tell them that their behavior is offensive, because believe it or not, in at least 50% of the cases, and I've investigated hundreds in my life, the person doesn't even realize what they're doing is offensive. However, that can often be highly unrealistic when it's your boss, and in particular if the boss is the CEO or owner and there's no other person that you can go to, and retaliation can easily occur and there's no alternative for you. So a person like that needs to understand that if they do take that action of sitting down and talking to their leader, they need to document it. And in some states, they can actually record it without the knowledge of the other person. And in some states, they have to let the person know they want to record the conversation. And their option is, if indeed the harassment continues or if there's retaliation, then they can go file a charge. And they need to recognize that retaliation can often look like termination of employment, and they could be unemployed while dealing with the legal track of filing a charge, waiting for an investigation, et cetera, which can be very lengthy at times.
Let me ask you a real quick follow-on question, Lisa. So the person comes in and they sit down with the boss and they say, hey, you're doing these things and it's making me very uncomfortable and I'd like to ask you to, I assume that that's the way the conversation would go. And then the boss says, oh, I didn't realize, I'm really sorry. Does that make the boss culpable at that point legally? Has he admitted to that by the apology, or how should the boss respond?
It depends on whether the actions that that boss took rose to the level of sexual harassment. So an employee might go to a boss and tell them they're uncomfortable, and those behaviors might not be severe or pervasive enough to rise to the level of sexual harassment. So in that case, there's probably not an actionable claim. However, if they did rise to the level of harassment and they stop, and there is all the other things in place that I'm going to talk about, then they might have a defense. But if they either don't stop, or it had the effect of interfering with that person's employment, or they retaliate, then there's going to be a serious issue for that employer.
Yeah, I think it's a very difficult situation, Fred, for smaller jurisdictions and smaller corporations or mom and pop operations, because they generally don't have a big staff. They don't have necessarily even an outside HR person. And very often the lawyers are kind of their mom and pop enforcers, So I think those situations are very hard to unravel, and very often, regardless of what happens, lead to charges and termination, et cetera. And everybody comes out with egg on their face. The best thing to do is, no matter what size employer you are, to try to get good policies in place, to try to do the training that Lisa alluded to, and to try to avoid the situation, because I have not seen a happy resolution once the issue comes out in a small organization.
Back to the things that an employer can do to help the possibility of a charge or have a defense. So I'll list them quickly, and then I'll go into a little bit about what they are. So we talked about policies and training. The next ones are having an accessible and trusted complaint procedure, doing immediate investigation of complaint or claims, the leadership actions and behaviors we'll talk about, and then confidentiality. So we've already talked a little bit about the accessible and trusted complaint procedure. So I think we've covered that. But again, it's important that there's either somebody internally, such as HR, or you should also suggest that they're allowed to go to their boss, if that's not the harasser, their boss's boss, any leader in the company, and report it, or an ombuds person if the company is large enough to have that, or an outside agency if necessary. Mm-hmm. And regarding investigations, this is what's important. No one should receive a complaint or become aware. No leader in the organization should become aware of any concerns or allegations and then sit on it or not take it seriously. They should, if it's a small company, investigate it. And if it's a larger company, ensure that the HR department or the group that does such investigations, it might be a legal group, looks into it immediately. Now, a lot of times the investigations don't turn out to rise to the level of sexual harassment, and it might be that it's just a conversation with the person who's engaged in behavior that makes someone else uncomfortable. But again, they have to follow up on it and investigate it. And this really leads into what I call leadership actions. Leaders need to walk the talk. And they also need to reflect a balance in the workplace, and that will also help to ensure a reduction of sexual harassment. What do I mean here? Well, if you have a board of directors, an executive leadership team, a management team, and even employee base that's fairly represented by women, the research has showed that you're going to have a significant reduction in claims and actual behaviors that rise to the level of sexual harassment. Leadership needs to demonstrate zero tolerance for inappropriate behavior, and they have to do this through their own behaviors, their own actions, their role modeling. They have to role model not only this ideal behavior, but they have to role model how you react if you see someone else doing it. They have to call it out, and they have to take immediate action. And I think the last thing I wanted to bring up is if an investigation is occurring, or if indeed an allegation has been made, it's important that you do everything you can to maintain the confidentiality of the person who has both made the allegation and has been accused, but don't promise any confidentiality. Because at times, when you're doing the investigation, as you're asking questions, it might become evident to the people being interviewed what you're talking about. So once you've made that promise of confidentiality, you might not be able to keep it in order to do an efficient investigation. I'm sure Susan has some thoughts on this.
I definitely agree that it helps if you've got women in the process because it very often changes the outcome. Women and men, unfortunately, still look at things in different ways, and you might be able to obfuscate the problem if somebody just recognizes that there is a problem or there is an issue or somebody's concerned about something. And that might make it go away just because somebody's hearing what's being said as opposed to avoiding the situation. I think also organizations sometimes have something called a hotline where if you're too embarrassed about going face-to-face with somebody, maybe Lisa doesn't like this, but at least there's a telephone number that you can call and say, I saw this happening, or this happened to me or whatever. And the hotline person will know and be trained on how to deal with it or whether you can go forward from that procedure. And one of my issues is that the employer and the accused are better off if you are on the same side, but the employer can't always guarantee the accused that we are going to represent both the employer and the accused, because that may go counter to the law.
I think it really comes down to having the right policies and training in place and then following them consistently, always and immediately. That would be my advice.
My guests today have been Lisa Barrington and Susan Savitt. Thank you very much for this very enlightening discussion.
Thank you for visiting with us. We welcome your comments and suggestions and look forward to having you join us soon at Workplace Strategies.